हे एवरीवन। तो आज हम लोग देखेंगे इमरजेंसी प्रोविजन फ्रॉम परीक्षा मंथन एंड लेट्स स्टार्ट। एप्लीकेटली कॉन्स्टिट्यूशन इज एन इमरजेंट सिचुएशन एंड हॉलमार्क ऑफ द इंडियन कॉन्स्टिट्यूशन। ठीक है, इमरजेंट सिचुएशन कंप्रोमाइजेज ऑफ द एक्स्ट्राऑर्डिनरी सिचुएशन, देयरफॉर कॉल्स फॉर द एक्स्ट्राऑर्डिनरी measures legally federal of the largely the federal structure of the constitution gets converted into the unitary status। तो इसमें ये भी हम लोग बोल सकते हैं, ये जो स्टेटमेंट है फेडरल हमारा यूनिटरी में हो सकता है और एक यूनिटरी में हो सकता है। दैट्स व्हाई दिस इज वन ऑफ द रीजंस व्हाई इंडियन कॉन्स्टिट्यूशन इज criticized। Moving forward, the normal fabric of the constitution is adversely affected. Constitution makers felt it prudent in emergency situation that the union government should have ordinary powers, have overriding powers, keeping in mind adverse situation of the country may face. The constitution makers incorporated elaborate provisions relating to the emergency। तो बेसिकली 3 टाइप्स ऑफ इमरजेंसी होते हैं: नेशनल इमरजेंसी, स्टेट इमरजेंसी और फाइनेंशियल इमरजेंसी। नेशनल इमरजेंसी 3 ग्राउंड्स पे हो सकते हैं गिवन इन आर्टिकल 352: वार, एक्सटर्नल आर्म्ड रेबेलियन, फेलियर ऑफ कॉन्स्टिट्यूशनल मशीनरी दैट इज स्टेट इमरजेंसी। वो उसके ग्राउंड से फेलियर ऑफ कॉन्स्टिट्यूशनल मशीनरी इन द स्टेट और फेलियर टू कंप्लाई विद द डायरेक्शंस ऑफ द स्टेट। 356 डायरेक्शन ऑफ द स्टेट बोले तो वो डायरेक्शन मतलब कि यहाँ पर स्टेट का मतलब यूनियन हो गया। ठीक है। फाइनेंशियल इमरजेंसी, थ्रेट टू फाइनेंशियल स्टेबिलिटी और क्रेडिट ऑफ इंडिया, आर्टिकल 360। नेशनल इमरजेंसी में हो गया 352 आर्टिकल 352 क्लॉज 1 प्रोवाइड्स दैट प्रेसिडेंट इज सेटिस्फाइड दैट grave emergency exists whereby security of India or any part thereof is threatened by war, external aggression or armed rebellion. He may by proclamation make a declaration that the effect in respect to that effect in respect of whole of India or such part of territory। तो बेसिकली ये देख लो आप लोग कि पूरे इंडिया में हो सकता है या कोई स्टेट के पार्ट में हो सकता है। ठीक है। देयर ऑफ एज मे बी स्पेसिफाइड इन द प्रोक्लामेशन। द प्रेसिडेंट कैन इशू डिफरेंट प्रोक्लामेशन ऑन द डिफरेंट ग्राउंड्स whether or not proclamation of emergency proclamation is in operation or not। Armed, the insertion of the word armed rebellion was inserted by the 44th Constitutional Amendment Act। In the place of internal disturbance, Supreme Court in Naga People Movement of Human Rights versus Union of India held that the expression internal disturbance has a wider connotation than the armed rebellion. Armed rebellion is likely to pose threat to the security of the nation or part of it, whereas internal disturbance though serious in nature would not pose threat to security of the country। The main reason behind the substitution of the word internal disturbance with the armed rebellion was to limit the scope of the proclamation of emergency to more serious situation। We have seen earlier that either emergency can be proclaimed either to the whole of India or a part of a country, and this proclamation can be made even there is an anticipation of the war, external aggression or armed rebellion that is provided under explanation to article 352, and the proclamation of emergency can be revoked by the president on a subsequent proclamation। Article 352 clause 3 provides that president shall issue or vary proclamation of emergency only when the decision of the union cabinet is communicated to him in writing, ठीक है। ये this is the new provision that has been inserted by the 44th Constitutional Amendment Act. And prior to this amendment, there was no requirement as such. And उसमें क्या होता था, पहले सीएम साहिबा जा करके प्रेसिडेंट को बोलती थी इमरजेंसी लगाने के लिए, तो प्रेसिडेंट लगा देते थे। एंड आफ्टरवर्ड्स काउंसिल ऑफ मिनिस्टर्स को सूचित किया जाता था। एंड टू बी वेरी ऑनेस्ट, दिस amendment was brought by the Janta government. Prior to this, there was a Congress party. The ruling of Congress party was there, and Indira Gandhi invoked the emergency on the ground of internal disturbances and misused her power. That's why, to increase the more accountability of the legislature with regards to the states and the union, this provision was enacted. Now, approval by the parliament, like the parliament has to approve the emergency within 1 month from the proclamation. And if the parliament is not in session, then if the emergency that the proclamation is passed by the Rajya Sabha, and then it has to be approved within the 30 days from the date when newly constituted Lok Sabha first sits. ठीक है। आर्टिकल 352 क्लॉज 6 प्रोवाइड्स कि जो रेजोल्यूशन है फॉर कंटिन्यूएंस ऑफ द असेंबली, कंटिन्यूएंस ऑफ द प्रोक्लामेशन or the resolution for proclamation must be passed by a special majority from the both houses of the parliament. Duration of the emergency can the minimum duration of the emergency can be of 1 month. That is when a proclamation is issued by a president, and then once it is approved by the both houses of the parliament, then it can remain effective for 6 months. And before 6 months, if any government wants to extend the further emergency, then before the expiry of the 6 months, it has to be laid down before the both of the houses of the parliament, and then only it can be effected for the next 6 months. And this can go up to infinite period, infinity तक जा सकता है। लोकसभा के पास क्या पावर्स रहता है? Lok Sabha can also allow discontinuance of the emergency. For that, 1/10 for that, a notice signed by 1/10 of the member of the Lok Sabha has to be given to a speaker if the house is in session, and to the president if house is in not session. And then from the date of the receipt of the notice, within 14 days, sitting is to be held, and then at that sitting, whatever the decisions comes out, that will affect. So basically, Lok Sabha can discontinue the emergency also. Now let us see the effect of proclamation of the emergency. Center assumes wide power, and center-state relationship undergoes a drastic change. Following are the effects of the proclamation of the emergency. According to the Article 353A, executive power of the center shall extend to giving directions to the state as to the manner in which executive power is to be exercised. वेट अ मिनट, 1 मिनट का बस मेरे को ब्रेक दो। So I'm like मैं अपने नोट्स भी निकाल लेता हूँ कुछ एडिशनल पॉइंट्स होंगे तो आई विल लेट यू नो। हाँ, तो क्या होता है कि जो एग्जीक्यूटिव पावर ऑफ द यूनियन कैन एक्सटेंड्स टू द गिविंग डायरेक्शन टू द स्टेट्स। ठीक है। Since the parliament can make laws even in the state list, it means center can give directions even in those areas in which are normally allotted to the states. तो पहला हो गया गिविंग डायरेक्शंस। To the states with regard to executive power, दूसरा हो गया पार्लियामेंट कैन मेक लॉज, the parliament can make laws, confer power or impose duty with respect to any matter in the state list. When the proclamation of emergency is operation in any only in a part of a territory of India, the executive power of parliament to give directions under article 350A and 350B shall also extend to any other state other than the state in which other than the state or part in which the proclamation of emergency is in operation. मतलब कि वो और भी स्टेट को डायरेक्शंस दे सकता पार्लियामेंट। 354 states that alteration of the distribution of the revenue, that is financial relation. 268 to 79 discusses about the financial relations between state and unions. ठीक है। The normal financial arrangements between the center or state cannot function because the financial needs of the center are far greater than the financial needs of the state. Article 83 clause 2 provides that during the proclamation the president can extend Lok Sabha by a year and each time up to a fixed period not extending to the 6 months after the proclamation ceases to operate. Means the Lok Sabha can be extended by a year each time. मतलब कि it can be extended to a year and when proclamation ceases to operate then it can be extended for the 6 months only. अब 6 months के अंदर आपका लोकसभा डिसॉल्व हो जाएगा। Provided to the article 172 provides that parliament may by law extend the life of the state legislature by 1 year each time during the emergency. To article 3 clause 2 and proviso to article 172 both provides the extension of the Lok Sabha and the state legislative assembly. Article 250 states that ki center gets the power, the union parliaments becomes empowered to make laws with respect to the state list and such law। और जो लॉ वो बनाएगा पार्लियामेंट बनाएगा वो 6 महीने तक ही ऑपरेट करेगा। दूसरा एस्पेक्ट होता है सस्पेंशन ऑफ द फंडामेंटल राइट्स अंडर आर्टिकल 19। जो फंडामेंटल राइट्स हैं हमारे वो आर्टिकल 19 के अंडर जो हमारे फंडामेंटल राइट्स है वो सस्पेंड हो सकते हैं। प्रायर टू 44th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, according to article 358, as soon as the proclamation of emergency was made under article 352, article 19 was suspended. There was automatic suspension of article 19 as soon as proclamation of emergency was made under article 352. Such suspension removed fetters imposed by article 19 on the legislative and executive power. It means that if the legislature made any law or executive took any action either during the continuance of the emergency, oh sorry, executive took any action which was inconsistent with the rights guaranteed under Article 19, then the same cannot be challenged either during the continuance of emergency or afterwards. It must be noted that article remained suspended only till the proclamation of energy. As soon as the proclamation of energy ceases to have effect, the legislative enactments passed or executive action taken during the course of emergency becomes inoperative to the extent of the conflict with the Article 19. However, Article 358 made it clear that things done or omitted to be done during the emergency could not be challenged before the emergency was over. तो इसमें एक केस आता है एम पाठक वर्सेस यूनियन ऑफ इंडिया. एम पाठक versus Union of India. Let me open my notes and I will tell you what exactly the case is. M. Pathak versus Union of India. In this case, it was held that the rights guaranteed by the Article 14 and Article 19 are not suspended, but only their operation is suspended. This means as soon as emergency is over, rights are transgressed by the law. Rights that are transgressed by law will revive and can be enforced. Article 358 and 359 1A provides that as soon as the proclamation ceases to operate, the effect of the suspension must vanish except as the respect things done or omitted to be done before the law ceases to have effect. So this was the case M. Pathak versus Union of India. Basically अगर इसके फैक्ट्स को देखा जाए तो कोई इंश्योरेंस कंपनी का जो उन्होंने लॉ बना दिया था करके कि ऐसा ऐसा होगा और उसी से रिलेटेड M. पाठक वाले हमारा केस था. तो ये जो हमारा था प्रायर टू द 44 कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, ये था पोजीशन आफ्टर द 44th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. According to the amended Article 358, there is an automatic suspension of Article 19 as soon as emergency is proclaimed on the grounds of war or external aggression. ठीक है, तो automatic suspension of Article 19 is on only the two grounds, that is war and external aggression. Article 19 is not suspended in case of proclamation of emergency on the grounds of armed rebellion. Proviso to Article 358(1) provides that proclamation of emergency is in operation only in part of India. Any such law made or executive action taken in relation to such area which proclamation of emergency is not in operation, the provision makes it possible to extend any law of executive action or the executive action taken in the part in which emergency prevails to any other part of the country if activities therein threaten the security of the India. तो बेसिकली व्हेन it tries to state that कि अगर एक पार्ट में आपका प्रोक्लामेशन सस्पेंडेड है, प्रोक्लामेशन ऑफ इमरजेंसी है एंड तो फिर उससे रिलेटेड आप दूसरे स्टेट में भी आप एक्सटेंड कर सकते हो. ठीक है, कब कर सकते हो? when there is a ground to believe that the security of India is threatened or any part of India is threatened. Was inserted. Further, Article 358(2) was inserted. According to it, Article 351 does not apply to any law or executive action taken under it, which does not contain recital to the effect that such law in relation to the proclamation of emergency. It is a well settled principle that Article 19 is suspended only with respect to the law enacted during the emergency. It does not get suspended vis-a-vis pre-emergency laws. Okay, therefore, it follows the validity of all laws enacted during the proclamation. It follows that the validity of all the laws enacted during the proclamation of emergency cannot be challenged on the ground that it infringes the Article 19, whereas the validity of pre-emergency laws can still be challenged on the ground. Okay, in the case of state of Madhya Pradesh versus Bharat Singh, held that Article 358 is prospective in nature. It cannot validate any legislation which uh, it cannot validate a legislative provision which was invalid because of constitutional inhabitation before the proclamation of emergency. तो बेसिकली क्या है, ये कहना क्या चाह रहा है कि सपोजिटली यहाँ कोई लॉ है, यहाँ इमरजेंसी आ गए और ये हो गया हमारा पोस्ट इमरजेंसी का सिचुएशन, ठीक है। तो यहाँ पर ये लॉ वाज वायलेटिव ऑफ आर्टिकल 19, ठीक है। इमरजेंसी के टाइम में वही लॉ को इनैक्ट फिर से कर दिया गया, ठीक है। तो जब तक इमरजेंसी यहाँ से यहाँ तक मान करके चलो इमरजेंसी चल रही है, तब तक ये लॉ वैलिड रहेगा, दिस लॉ विल बी वैलिड। बट एज सुन एज द इमरजेंसी सीजेस टू ऑपरेट, दिस लॉ विल बी इनवैलिड, दिस लॉ विल बी इनवैलिड। मेरे अंडरस्टैंडिंग के हिसाब से यही है। As soon as the emergency come to the end, Article 19 again become operative. A law inconsistent with the Article 19 passed during emergency ceases to operate with the extent of the inconsistency. However, Article 358 makes it clear that things done or omitted to be done in the emergency cannot be challenged if even after the suspension of emergency is over. हाँ, तो आप इस टाइम पे इस टाइम पीरियड पे कुछ भी हुआ है, कोई भी लॉज हुए, कोई भी राइट्स वायलेट हुए हैं, तो वो चैलेंज नहीं हो सकते। लेकिन इमरजेंसी जैसे ही ख़त्म होगा, जो लॉ आर्टिकल 19 के साथ इनकंसिस्टेंट है, दैट विल बी वैलिड। सस्पेंशन ऑफ द फंडामेंटल राइट, सस्पेंशन ऑफ द राइट ऑफ इन्फोर्समेंट ऑफ फंडामेंटल राइट। सॉरी, इसमें भी पोजीशन प्रायर टू द 44th कॉन्स्टिट्यूशनल अमेंडमेंट अकॉर्डिंग टू आर्टिकल 359 एज इट एग्जिस्टेड provided that the enforcement of all fundamental rights and other than article 19 as it is the subject matter of article 358 could be suspended during the emergency by an executive order where the proclamation when the proclamation of emergency is in operation, the president could by an order declare that right to move to any court for enforcement of fundamental right, and all proceedings pending in the court for the enforcement of all that right remain suspended. National emergency was declared in 1975 on the ground of internal disturbance, that is Indira Gandhi ka sarkar. In pursuance of it, via a presidential order under Article 359, right to access to courts for enforcement of fundamental rights under Article 14, 21 and 22 were suspended. Presidential order under Article 359 suspending the enforcement of the fundamental rights was challenged before the Supreme Court in ADM Jabalpur versus Srikant Shukla in 1976. Supreme Court held that during the proclamation of emergency rights, and the Article 21 can also be suspended, and no person shall have any locus standi for enforcement of such right. Court held that any claim to a writ of habeas corpus to challenge the detention on any ground amounted to the enforcement of right under Article 21, which was suspended by presidential order under Article 359. This meant that the person can be imprisonment without giving any relief whatsoever. This case is also known as habeas corpus case. अब ये था एडीएम जबलपुर वर्सेस शिवकांत शुक्ला वाला, आया था प्री इमरजेंसी, ठीक है, प्री 44th अमेंडमेंट 44th CA। अभी ये है पोजीशन आफ्टर 44th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट। 44th Constitutional Amendment Act restricted the scope of the Article 359. It was amended to provide the presidential power to suspend the right to move to any court for the enforcement of the fundamental right cannot be exercised with respect to the rights guaranteed under Article 20 and 21. So it was amended to provide that the presidential power to suspend right to move to any court for enforcement of the fundamental right cannot be exercised with respect to the rights guaranteed under Article 20 and 21. Thus, it was no longer possible to suspend the rights guaranteed under Article 20 and 21. Therefore, the current position is that under Article 359, when a proclamation of emergency is in operation, the President may by order declare that the right to move any court for the enforcement of any fundamental right, except Article 20 and 21, as may be mentioned in the order, and all proceedings pending in the court for the enforcement of any such right may remain suspended for the period of emergency or any shorter period. तो ये हो गया. सो हमारा एक एमसीक्यू में क्वेश्चन आता है, विच ऑफ द फॉलोइंग आर्टिकल्स कैन नॉट बी सस्पेंडेड ड्यूरिंग द प्रोक्लामेशन ऑफ इमरजेंसी, एंड दैट वुड बी आर्टिकल 20 एंड 21. आर्टिकल 19 वाले चीज भी तो हमने देख लिया है, कैन बी सस्पेंडेड. आर्टिकल 19 टेल्स स्पीच, क्या बोलते हैं उसको, right to speech and expression. It is also provided that the suspension of the enforcement of any fundamental rights under Article 359 shall not apply to any law which does not contain recital to the effect that such law is in relation to a proclamation of emergency. ये बहुत बेढंगा आर्टिकल है. Article 359(1)(a) provides that while an order under Article 359(1) is operation, no fundamental rights except Article 21 and 21 shall restrict the power of a state to make any law or to take any executive action. It means that if a legislature makes any law or takes any executive action which is inconsistent with the fundamental rights mentioned in the presidential order, the same will not be challenged. मतलब कि आप 20 और 21 को छोड़ करके कोई भी फंडामेंटल राइट को सस्पेंड कर सकते हो, बट सच लॉ और एग्जीक्यूटिव एक्शन shall cease to have effect as soon as presidential order ceases to operate. ठीक है, तो जैसे ही लॉ खत्म है, सेम एज द आर्टिकल 19 वाला सिचुएशन. आर्टिकल 359(3) provides that any order made under Article 359(1) shall, as soon maybe after it is made, be laid down before हाउस ऑफ पार्लियामेंट. तो बेसिकली जो भी 359(1) में जो भी कानून बनाया गया है उसको बोथ द हाउसेस ऑफ द पार्लियामेंट के पास रखना जरूरी है. मिलते हैं नेक्स्ट वीडियो में.